So today we have with us two speakers whom I have no hesitation in describing them as exceptional. And so it's an honor to welcome Liz and Guillaume. So the collaboration with Guillaume started in a rainy day of June 2018. The French historian Henry Rousseau recommended me in his office to get contact with the legal historian and sociologist Guillaume Morales, who is working at the Center Marc Bloch in Berlin. So we're starting working together, exchanging information on lawyers involved at the Nuremberg and Tokyo trials. So Guillaume is an expert in history and sociology of law, post-war justice, purges, and mass crimes trials. And his work is really innovative. And I really like his work because he has this historical commitment to digging into the archives to provide a new lecture in legal history. And so in his first book on the German purge in GDR, he worked with innovative German sources. And it's also interesting to say that by 2012, he discovered the files of Henri Donadieu de Valre, the French lawyers at the Nuremberg trial. And then his approach to history, is marked by traditions inherited by the Annales school. So I saw the influence of Marc Bloch, Maurice Halbwachs also, and Norbert Elias. But when we work with Guillaume, he always say, I'm a specialist in the socio-history. So the socio-history emerged in the 90s, and it emphasized the socio-origin of the historical phenomena. And interestingly, he see post-war trials as part of the end of the war. So it's a French concept, it's a sortie de war. It's really analyzing the process of resetting population, the demobilization of states, economies, and armies. And he published by 2014 a book dealing in English. It's entitled Dealing with Wars and Dictatorship, Legal Categories and Concepts in Actions. So I started at the end of the year 2019 to translate his book into English. So his book on the Nuremberg moment, which was published last year at Sciences Po University Press. And his book enlightened the legal constraints on American lawyers in the preparation during and also after the Nuremberg trial. And one of his chapter really demonstrate how the racial and cultural questions impacted the innovation of the crimes against humanity. So, and when Guillaume accepted for a few weeks to present his book at the seminar, I thought directly Professor Elizabeth Borkwhite, Liz, would be the best commentator, since I really saw her influence on the book. And so when I contacted her, I got a few hours later a lovely and enthusiastic yes. So thank you, Liz, for your answer.
I was honored.
So most of you knows you, associate professor of history and law at Washington University in St. Louis, and expert in the history of international law with a focus on human rights and institution. And your book, A New Deal for the World, America's Vision for Human Rights, published at Harvard University Press, describes how a cadre of World War II American planners inaugurated the ideas and institutions that underline our modern international human rights regime. So Liz is something like a polyglot. So in addition to her Stanford doctorate, you earn a GD from Harvard Law School and MPhil in International Relations from Cambridge University. So Liz is also clerk on the Ninth Circuit Court of Appeal and is a member of the California Bar. And additionally, she has held fellowships with Harvard, Stanford, Berkeley, NUI, and the Holocaust Memorial Museum, as well as a Fulbright professorship with the University of Heidelberg. And she has recently served also at the Richard and Ann Paulson Visiting Professor of Human Rights at the University of Chicago. So the issues to discuss today is that the Nuremberg moment and the racial question at the Nuremberg trial. And this question is really raised increasingly frequently in international law, human rights, and also global history. And for me today, the seminar is not just a book presentation or a discussion. It's also a meeting between different academic cultures. And when we see Guillaume's work and also Lee's work, I would say that this meeting is entangled between a socio-history of the American lawyers at the Nuremberg Tribunal and in an in-depth analysis of their interactions of ideas, individuals, and institutions that transform American foreign policy.
So thank you very much to Anne-Sophie for her very kind invitation to this very exciting seminar. Many thanks also to Elisabeth Borgward for accepting to comment on my presentation and on my book. I'm very grateful to her. So to begin, some introductory remarks on the book and the intention and on the intention of mine while writing this book. It is possible to say, the first question maybe is it possible to say something new about the main Nuremberg trial? My research work, I think, offers a renewed look at the Nuremberg object by approaching it from the angle of the social history of the legal professions on the first hand, and by crossing either two largely separate lines of research on the second hand. Also, my book is not a book on the international Nuremberg trial itself, but rather a book on the allied jurists who conceived, elaborated, and implemented the legal framework of the International Military Tribunal. In particular, in this book, I focus on the American lawyers who played a key role in this story. Secondarily, the book deals also with those activists in the United States who seized or who appropriated since 1945 the legal tools forged in Nuremberg to advance their own cause, whether fighting domestic racism or later denouncing war crimes in Vietnam or elsewhere. This research is based on a strong hypothesis. It's the starting point of the research. To better, and this hypothesis is the following: to better understand what the protagonists thought and effectively did in Nuremberg and in the preparation of the trial, I think we have to take seriously into account the social and professional properties of the protagonists, of the actors. It is a belief anchored maybe in the sociology, social fields. That means that there is a strong correlation between position held by the actors and the statement, the thoughts, the action of these actors. To do so, for me, means a system, means for my purpose, for my research object, that means a systematic description of the population at hand. That is the population at hand. I'm allied staff, the allied employees at Nuremberg. And this description, I tried to make this description both synchronic and diachronic. It was a very time-consuming task, but only this very time-consuming task allows to sketch the social space or the set of interweaved social spaces to which the actors, the protagonists belonged. To properly link actual practices and the properties, the social and professional properties of the actors, I led in parallel two inquiries. First, a so-called prosopographic or multi-biographic inquiry, allowing for statistical analysis of the considered population. Second, a more qualitative and more classical, maybe, investigation based on archives onto the genesis of key legal innovations of the Nuremberg trial, mainly crime against humanity. Exploring the relationship between social properties, cognitive schemes, and practical sense of the actors helps to better understand how legal innovation was working in the war and in the post-war context. Innovation was often conflicting and tense. It was very rarely harmonious and cooperating. It was conflicting. It was also, and it's a very important point, it was also a constrained process. Because the way of innovate depended heavily on the actors' own mode of socialization, as will be shown later in my presentation. I hope my English is okay.
Oh, it's fine.
Because I'm not very, I don't use to speak English.
No problem.
So the first point of my presentation, after this short introductory remarks, will be some words on the limited and contorted definition of racist crimes in international law, and especially in the first definition, in the first attempt to define international crimes in legal history, that is in the Charter of the International Military Tribunal. I come now so to the core of the presentation, devoted to one aspect of the book, namely the question of how atrocities and persecution on racial grounds, to quote the words of the actors, the contemporary expressions of 1944 and 1945, to understand how atrocities and persecutions on racial grounds were sought and legally conceptualized during the Second World War, was one of my important questions. In other words, I sought to revisit the genesis of crime against humanity as a category of international law because this first definition was included, this first definition of racist crimes or crimes on racial grounds was included in the definition of crime against humanity in the Charter of the International Military Tribunal. As many authors have shown since at least the 1970s, the core of the definition laid down in the IMT Charter arose from a complicated, nonlinear process initiated in the United States War Department during the summer of 1944 and driven by a team of well-established East Coast lawyers. This genealogy does not imply that a reflection on that very topic was not carried out in other arenas, in other places by other actors. However, the proposals made by these later actors were generally not seriously taken into consideration by the policy makers in charge of these issues at the time. A significant part of National Socialist or Nazi crimes were not punishable under the existing laws of war, especially the so-called atrocities on racial grounds, as the Allied experts referred to, atrocities committed by the Axis powers before or during the war against their own nationals. Consequently, various experts, most of them outsiders within the academic legal field, proposed to adapt existing international law to this new situation. While most attempts made until 1944 to take into account those atrocities went through broadening the well-established concept of war crimes stricto sensu, morally creating a new category ex nihilo, the solution devised within the American administration and finally retained was substantially different. This solution subordinated those atrocities to other war-related crimes, among which the conspiracy to wage aggressive war occupied a prominent place. This subordination had, for two reasons, significant restrictive effects. It made the burden of proof especially difficult. It made it more generally very difficult to universalize the new category. And it's a very important point for me. Furthermore, to quote the French judge at Nuremberg, Henri Donnedieu de Vabre, I quote, "The category of crimes against humanity, which the statute had brought in by a tiny door, was as a result of the judgment volatilized." So it's disappeared. In the book, I wonder how this somewhat puzzling legal device was developed and why it was ultimately adopted in the IMT Charter. From my viewpoint, the mainstream, somewhat disembodied history of legal and political ideas, that is a story of political and legal ideas that pays little attention to the social groups involved in innovation processes. This kind of history cannot address these issues in an adequate way. It would benefit from being combined, to my point of view, with a social and professional history of the actors involved in the war crimes discussions, as well as with a broader examination of the way in which these actors justified their own actions. I argue that, among others, two sets of constraints weighed heavily on the process of legal innovation at the end of the Second World War and in the immediate aftermath of the war. On the one hand, a kind of professional constraint arising from the specific legal experience accumulated by the actors before and during the war. On the other hand, a form of internalization of the state's cause with regard to the principle of sovereignty and its domestic implications. This self-restraint, to use a concept by Norbert Elias, this kind of self-restraint specific to government lawyers, or what in French we call légistes, had an hampering effect on legal innovation. Furthermore, as will be shown, targeting a policy based on statutory racism was likely to raise domestic questions given the existence of a legal segregation, the Jim Crow laws in the southern states and similar provisions in the north, as well as the endemic violence against African American condoned by local authorities, for instance, lynching. Since Hitler came to power in 1933, African American publications, especially newspapers, regularly documented the anti-Jewish persecutions in Nazi Germany, highlighting the parallels between the Nuremberg and the Jim Crow laws, pointing from 1942 on the contradiction between domestic and foreign policy. However, these newspapers, also widely circulated, formed themselves a relatively isolated part of a strongly segregated public space in the United States. As for the legal experts in charge of the war crimes policies in the administration, they were, for some, aware of the possible domestic implications of the war crimes policy and warned explicitly, albeit never publicly, as I show in the book. So this warning was always internal within the administration and was never expressed publicly. They warn explicitly against any overly broad definition of crimes against humanity. For the reason it could be something une menace. I don't know how do you say something dangerous for the sovereignty of the judging powers. Not only the American power, also I will come to this point later, also the other allied powers. The elaboration of legal categories during the Second World War was not only a constrained process, it was also more than usually admitted, often confrontational. The seemingly purely legal or technical controversies did not unfold in the smooth space of epistemic communities, harmoniously working towards the development of international criminal law. The outcome of the more or less discreet struggles for legitimate and effective expertise in this area depended in particular on the positions the protagonists held within or in some cases out of what we can call the allied field of power during the war. And this Allied field of power was very differentiated and very asymmetric. For instance, the experts from the exiled governments in London had no important voice in this field of power. And it depended also on the unequal distribution of professional, political, and academic resources among these various experts. And so I come now to my second point, towards a legal category, the space of experience of government lawyers in Washington at the end of the war. Also, how were persecution and atrocities on racial grounds conceptualized? Two phases, two stages could be distinguished. High-profile experts in the foreign service, typically owing strong political, diplomatic, and legal resources, dominated the first stage, and these experts played an important role in an institution such as the United Nations War Crimes Commission in London. These experts were reluctant to give substance to the public commitments by the Allied powers. This made clear, especially from 1942 on, that the punishment of Nazi war crimes was one of their main war aims. However, the American government hesitated until 1944 to go beyond the restrictive definition of war crimes in international law, despite the growing concern over Nazi mass crimes against European Jews. The various proposals made to include persecution on racial grounds within this definition were rejected, especially from State Department officials, and it had been shown by different historians before. Another type of legal experts, this time practicing lawyers mainly based in the United States War Department, took over in the second stage, beginning in the summer of 1944. While they proved to be more imaginative or creative than the members of the previous group, they were no less dependent on their professional rationales as well as on the partly internalized state cause. In August and September 1944, a well-documented struggle took place within the Roosevelt administration to control the pacification of Germany, whose defeat seemed now imminent. It's a very famous struggle between the Treasury Secretary Morgenthau, who argued for a strong peace, a Carthaginian peace, including summary execution of the Nazi leaders. For various reasons, I don't want to develop this very well-known point, but I have to recall it. For various reasons, his colleague of the War Department, Henry Stimson, who opposed the so-called Morgenthau Plan and advocated with President Roosevelt a trial of the major war criminals. Stimson and his deputy, John McCloy, encouraged lawyers of their department to develop a workable plan. On September 15, Colonel Murray Bernays, a New York trial and appellate lawyer, forwarded them an also well-known memorandum entitled Trial of European War Criminals. Bernays aimed at solving the legal problems posed by the bureaucratic organization of Nazi crimes and the large number of perpetrators. And to solve this problem, he introduced two concepts hitherto absent in the academic discussion on war crimes: the categories of conspiracy on the one hand, and the category of criminal organization of the second hand. So the shared professional experience of Bernays and his chiefs explains to a large extent their enthusiastic support for this plan. After acceptation of the Bernays memorandum by the Secretary of War, it has been subjected to a drafting process from October to December 1944, involving a wide range of officials and legal experts, more or less expressing reservations towards an approach of German war crimes in terms of conspiracy and criminal organization. While some criticisms had something to do with the struggle of professional jurisdiction, in the sense of Andrew Abbott, as in the case of the Judge Advocate General, traditionally entrusted with war crimes matters. Other criticisms were more substantial. And it was a little long, sorry, but now come the important point. One of the main points of criticisms was the link between conspiracy and on the one hand, and atrocities on racial grounds on the other hand. These atrocities on racial grounds were partly committed against Axis nationals, also nationals of the Axis countries, and a part of these crimes were committed before the outbreak of the war. That means without link to the war, without direct link to the war. I come to my now to my last point: sovereignty and state-sanctioned racism, the minority problem, to quote the trial plan or trial project of Murray Bernays. The narrow definition of atrocities on racial grounds through a connection to other crimes was not only the product of the professional savoir-faire shared by the War Department's lawyers. The other side of the same medal was the strong concern among the American drafters of the legal Nuremberg framework, strong concern for the issue of sovereignty. To make legal innovation acceptable and workable, they should not radically challenge this principle. That was the point. By linking atrocities on racial, religious, political grounds with a legal theory based on conspiracy and criminal organizations, Bernays attempted to solve another problem he called the minority problem. I quote Bernays, also a portrait of Bernays. Some of the worst outrages were committed by Axis powers against their own nationals on racial, religious, and political grounds. As to these, the offenders can plead justification under domestic law. Also, to call these atrocities war crimes would set the precedent of an international right to sit in judgment on the conduct of the several states towards their own nationals. This would open the door to incalculable consequences and present grave question of policy. In an earlier memorandum to President Roosevelt, Bernays' chief, Stimson, sought to refute the Morgenthau Plan in its various aspects while admitting a great difficulty in finding a legal basis to, I quote Stimson, a legal basis to try and convict those responsible for excesses committed within Germany, both before and during the war, which have no relation to the conduct of the war. I will be prepared to construe broadly what constituted a violation of the rules of war, but there is a certain field in which I fear that external courts cannot move. Such courts will be without jurisdiction to try those who were guilty of or condoned lynching in our country. And the racial question come in the discussion through this way, and it will be very quiet music that didn't disappear after that, but always internal in the administration, never publicly. This great difficulty was hard to solve without a conceptual framework allowing to link atrocities with the Nazi project of world domination. It may explain why, until September of 1944, those in charge of war crimes policies, not only in the state, but also in the War Department, were very reluctant to expand the traditional definition of the rules of warfare. Bernays admitted himself having changed his mind on this issue during the summer of 1944. Anne-Sophie, I have still little time, or?
Yeah, of course. Yeah, please. Yeah. It's interesting.
Okay.
Yeah.
Okay. Surprisingly, according to Bernays, one of the earliest supporters of his plan was Green Hackworth, who served as long-running legal advisor of the State Department and later as judge on the International Court of Justice after the war. His support was, however, far from being evident. Hackworth was, by his duties, particularly sensitive to issues of sovereignty. Hackworth perfectly embodied the self-restraint of government lawyers examined at the beginning or evoked at the beginning of this presentation. This self-restraint was partly conscious in the case of sovereignty, partly internalized or unconscious as for its racial implications. These two intricate dimensions can be found in the criticisms Bernays' plans faced within the administration in general and in the War Department specifically. Indeed, another set of concerns could explain the reservations about the inclusion of atrocities on racial grounds in the charges to be brought against Nazi leaders, especially when these crimes were not obviously connected to the war. The fear, and that is the fear of shaping an universal legal tool likely to pave the way for an international scrutinization of the American racial unequal order at the time. During the negotiations of the IMT Charter at the London Conference from June to August 1945, the chief prosecutor of the United States, Robert Jackson himself, stated without ambiguities to his British, French, and Russian counterparts that, I quote, it's also that, I quote, the way Germany treats its inhabitants or any other country treats its inhabitants is not our affair any more than it it is the affair of some other government to interpose itself in our problems. He further added, we have some regrettable circumstances at time in our own country in which minorities are unfairly treated. We think it is justifiable that we interfere or attempt to bring retribution to individuals or states only because the concentration camps and the deportations were in pursuance of a common plan or enterprise of making an unjust or illegal war in which we became involved. Quote end. In certain cases, and I go to my conclusion, in other cases, worries about too broad legal definitions of atrocities on racial grounds certainly reflected more internalized racial structures. They could also go along with particular concerns of Southerners, such as Jackson's assistant Sidney Alderman, who was personally committed to an unequal racial order, or with practical political concerns. For example, Secretary of War Stimson himself was acutely aware of the problem of this problem, for he regularly had to manage the problem of raised by the racial segregation in the military. The same observation applies to Undersecretary John McCloy, who, as chairman of the, I quote, Advisory Committee on Negro Troop Policy, was reluctant to put an end to discriminatory provisions in the army. To conclude, the analysis of my book underlines what a workable legal category means. Workable means that the innovation should not threaten the sovereignty of the prosecuting powers. African American publications often highlighted the irony of a situation where the US government was internationally advocating principles which were not domestically observed. To some extent, my analysis of how white Anglo-Saxon jurists had internalized the prevailing racial structures, it is consistent with that of the critical race theory. The last two chapters, and I conclude with this aspect, the last two chapters of the book focus on non-conforming, untimely appropriations of the legal tools forged in Nuremberg until the mid-1950s, especially by civil rights lawyers and African American activists who were fighting against the domestic racism. These non-conforming appropriations played a key role in the development of international criminal justice as a living dispositive in the sense of Michel Foucault. Indeed, at the time when the institutional construction of this justice was brutally cut off, inter alia by the American government for domestic reasons, this international justice continued its formation from below through various forms of appropriation and subjectivation. And it's very important to consider the two dimensions, not only the institutional construction of international justice from the top, but also, I think, its existence from below was very living in the decades after World War II. Thank you very much.
Yeah, thank you. Yeah, thank you very much, Guillaume.
Okay, so I'll be brief, relatively brief. How I wanted to structure this commentary was to just mention 4 aspects of this book that I think are very important interventions and that I really loved, and then to conclude with a couple of questions, actually mostly about those last two chapters, which got a little compressed of necessity in this presentation. So maybe that will can then segue into more of a dialogue if you answer those questions and then other people have questions. So, but I just wanted to start out by saying that, first of all, there's a perennial question that I think we both get a lot about, what new can be said. Can anything new be said about Nuremberg? And I'm a little impatient with this question, as you might imagine, because I mean, if you look at the American Civil War, for instance, Harvard's database has 15,000 books about the US Civil War, 5,000 on Lincoln alone, and people seem to think there's more to say. So I think there's a lot more to say in general on the topic of Nuremberg. And particularly, I think that this is an example of an intervention that is a rejoinder to that question, to say, well, there's a lot that's new to say. And not just through underexplored dimensions or underexplored subtopics, such as the so-called subsequent trials, which, I mean, there's a lot of new scholarship, but obviously not nearly as much as on the main trial, the IMT, but on the main trial as well. There is all kinds of new fields to till, and I think that your work is just a shining example of that. So you answer a lot of persistent questions. One of them is, what more is there to say about Nuremberg? And so the answer is a lot. I think you make a wonderful case for your title in terms of why is this a moment, how it's bounded, how it's constrained, how it really almost in effect goes away in terms of being frozen during the Cold War and then reemerging with the United Nations trials for the former Yugoslavia and Rwanda, and then ultimately the International Criminal Court. But that it's as you say, a bounded configuration of ideas and practices. And what you explore, as you did in your talk just now, what those constraints are, I think, beautifully. Thirdly, of course, the prosopography dimension of not a harmonious epistemic community, but still looking at, as a sociologist, what are the constraints and the environment and the terrain that these mostly American lawyers, mostly government lawyers, find themselves occupying. Does it make a difference if they're Southern? Does it make a difference if they're refugees? And then also being careful to distinguish various exceptions, Hirsch Lauterpacht, Sheldon Gluck in some ways. But just your exploration of these individual careers, I think, is tremendously additive, including the so-called bad guys like Green Hackworth, folks who are trying to shore up sovereignty. And why is he thwarting Herbert Pell? Why doesn't he just let Herbert Pell be Herbert Pell? Helps tell the story of the United Nations War Crimes Commission and why it was not more influential than it was. And fourth and finally, the story of Nazi pre-war atrocities and atrocities against German nationals or Axis nationals. Why so narrowly interpreted? And you answer that in two ways that are linked. Sovereignty, partly through framing your lawyers as these statist administrators, but also racism linked to protection of domestic jurisdiction, which is of course sovereignty, but this larger, you fit into a larger overarching story of basically racism as being the Achilles heel of particularly American and larger Western attempts at not just international criminal jurisdiction, but if you look at the United Nations other institutions. The protection of a special zone for domestic jurisdiction is absolutely about what you say it's about, right? Which is Robert H. Jackson saying, wait a minute. I mean, remember initially he thinks that the London Agreement is going to be a treaty that's going to have to go through the US Senate. And so he says, this is just a variation on some of the quotes that you've pulled out, but Jackson basically says, I really don't think that some of our Southern senators are going to love this idea of, and he doesn't frame it quite this modernly, but basically of the international community being able to reach back through this much vaunted veil of sovereignty, right, to pursue domestic abuses against a domestic minority population. Because what's the difference between that, besides obvious differences of scale, okay, but what's the difference between that in principle and lynching in the South, right? If you're mistreating of a domestic minority population as a sovereign entity, gives the international community rights of intervention against you, that's a terrible precedent and something that we want to stay away from. And then the rest of your story flows from that, about this sort of legal fiction, I guess, of that persecutions, pre-war persecutions, particularly against Jews, but also against Sinti Roma or homosexuals, or that part of it is kind of preparing a homogenous German folk that can better wage war. Mm-hmm. And that's the link, and that everybody just kind of agrees to go along with that. So, I mean, I think all of those things work dramatically well, and it's a wonderful intervention. And going through it, you explore all of these important cleavages between Soviets and the other allies, between the continental jurists and the Anglo-Saxon jurists, between the US Treasury and War Departments, professors and government lawyers, exiles and other kinds of outsiders and insiders. So all of these cleavages, or cross-cutting cleavages, because people are members of multiple categories, it's orchestrated very well to show why we would get the result that we get. And it also goes a very long way to helping us resolve one of the central paradoxes of the Nuremberg experiences writ large, which is, why is it that the thing we remember Nuremberg for is different than what everybody thought they were doing at the time? Mm-hmm. If you could, if I could follow a locution favored by one of my old law professors, the legal historian Morty Horowitz, he would say, you know, if you could wake someone up in the middle of the night, if you could wake Robert Jackson up in the middle of the night and say, what is this trial about while it's going on? He would say aggression, right? It's a trial about the outlawry of aggressive war. And yet a later unfolding in the post-war era means that insofar as the trial had legs, and I like that your term for legacy is legs, but that's a different term in English, like in terms of it literally having legs. Insofar as the Nuremberg idea had legs in the post-war era, it wasn't about that, right? It was about, as a kind of necessary precursor to the whole concept of the responsibility to protect, for instance, the idea that you can mess up your sovereignty so badly, you know, Syria, that it gives the international community a right of intervention against you. And Nuremberg doesn't go there in terms of, those are implications that, as Guillaume explains, are deliberately weakened and deliberately softened. So, and he refers to it as an ambiguous model. So my questions are mostly about your final two chapters, where you talk about the Nuremberg IMT as a limited resource for post-war mobilizations against domestic racism, this is in the US, and against military engagement in Vietnam. And you situate it in a context of Brown against Board of Education, accelerating decolonization, the reintegration of former Nazis into West Germany, the Russell Tribunal, which I'm fascinated by, and various kinds of Cold War concerns. So it explains why, you've explained why our progenitors in real time don't want a strong universal category. Mm-hmm. And yet that's exactly the dimension that these later activists for racial justice want to fish out. And you're very clear that these are, and you said in your presentation here, that these are marginalized individuals or representatives of marginalized communities. You do a great job with the Black press, for instance. So does that answer the question, I guess, of why why do we remember Nuremberg for things that it didn't want to do? Because those are the dimensions that are fished out and held up by these later activists. Although if we're saying that they weren't that powerful and they were so marginal, does it get you all the way there to say that this explains why we remember Nuremberg for something different than what Nuremberg was about when it was unfolding?
Yeah.
Is that fair? Or I can keep talking. You can write it down and I can add another question. But
yeah, you can add another question. Yeah, please, Liz.
Okay.
Yeah.
All right. Well, I just wanted to get it a little bit more in a dialogue mode, but also it's a little bit unfair to sort of have a 20-minute wind up to pitch a question. So, I'm just, so we still have a problem with even this, let's call it the activist memory of Nuremberg, right? Which is that crimes, international crimes, are recognized, they're legible to international criminal law still, sort of to the degree that they're more Nazi-like, right? If they're less Nazi-like, they don't, it's even harder. Okay, so it suggests on one level the power of Nuremberg to still shape that template that we put over our perception of even current atrocities. But it means, again, that the more Nazi-like they are, the more legible they are. And then maybe that gets you an elaboration of rules and norms related to incitement to genocide, for instance, gender crimes, and crimes of sexual violence, even aggression coming back a little bit, ethnic cleansing. All of those are have been elaborated in important ways in the post-war era. But then when you have international crimes that are environmental crimes, pillage as an environmental crime, other kinds of international, arguably criminal activity that is so far outside the purview of the Nuremberg model, it looks even paler and weaker, right, because of the power of the Nuremberg moment. And so maybe we don't want to strengthen the Nuremberg moment in that way, because it's not doing the work for us that we need it to do anymore. The subsequent, you talk about the subsequent weakness of the Nuremberg principles in the United Nations and how they kind of go the way of the ratification of the Genocide Convention, and why, again, that's such a problem in the United States, which is racism, right? You have that wonderful quote from Frank Holman, the American Bar Association head, who says, well, if I unfortunately hit a Negro child in the street, to use the language from the day, with my car, then I can be hauled up and tried for genocide in some international court. And although obviously that was incorrect at the time and is completely incorrect, it's still, that was the way to play the chords of American racism, which Raphael Lemkin did, which Hannah Arendt did. Mm-hmm. They didn't want their conceptions about rights and human rights to play into racialized American political debates. And so maybe
Guillaume, you can answer already, because yeah, Or Liz, do you want to add
Oh, well,
another?
just let me just wrap up that you conclude the book with a tantalizing question, which is, or framing, which is to say that, well, here are some things that were sort of weak coming out of Nuremberg. We thought it was going to be a big boost for individual rights. It kind of wasn't. We thought it was going to be a big boost for wars of aggression, outlawing wars of aggression. It wasn't. We thought it was going to be a big boost related to persecution of minorities. It wasn't. But what really had legs was this idea of a self-determination for minorities or for formerly colonized people, that's what went on to have this wonderful post-war afterlife, and that actually, Nuremberg has helped to reshape our thinking there as well. And so, I mean, I'd just love to hear you elaborate on that, I guess.
So, yes, one of the purpose of the book had many purposes, but one of the purposes of this book was also to understand the paradoxical position of the United States government in the history, in the long-term history of international justice. Because if we see the history of international justice from far, what we see is there is only one moment where the American government had supported and strong supported the project of an international justice. It was in the immediate after, in the period after the Second World War. It was not the case after the First World War, and since the end of the 1940s, it's not the case. So with maybe some different different periods, but in general there is a strong rejection of the principles of an international jurisdiction. I wanted to understand why, after the Second World War, the American government, the American legal experts, not only supported this project, but played a key role in the construction of this justice. So one of the answer is that they made this important step, but they made this step with strong limits, with strong reservations, with strong safeguards. They built, I speak very generally, but they built an international justice which was not very
robust.
Yeah, very robust and not dangerous for the American sovereignty. As well, it was not dangerous for the French sovereignty, the British sovereignty. It was the same. So it's a critical view on this Nuremberg moment, which is considered now as the first as the birth date of the international justice, with maybe too much emphasis by the naturally by the today proponents of international justice, such as the judges of the International Criminal Court today, when they fight against the Trump administration, they said, "Remember Nuremberg." But this genealogy is problematic, to my point of view. It's to some extent problematic, and I wanted to show that. But of course, with all reservation we can make towards Robert Jackson, it is impossible to compare Robert Jackson with conservative lawyers or politicians like John Bolton, so, for instance. It's very different people. Naturally, in the book, I think Robert Jackson believed in this new kind of justice. He believed, but with his own contradictions.
Definitely.
Yes, so I don't want to judge. I observe in this book. I observe a situation, and the situation is more problematic, more contradictory than it seems.
I'm just wondering, just quickly, and I'm abandoning my second question because it's too squishy, but do you have thoughts about why, for instance, the Geneva Conventions, the 1949 Geneva Conventions, seem to be so much more successful and pointed, I guess, to have legs in a way that the Nuremberg precedent didn't? Because it's a kind of flattening to say that all of these international initiatives for standards and norms were abandoned. And I'm genuinely curious about, what accounts for the success of an initiative like the Geneva Conventions when Nuremberg was so hampered.
I'm not sure.
It's a hard question. Yeah, no, I don't know. In the book, I don't focus especially on the Geneva Convention. No, I understand that.
But there is, I think, an interesting chapter by Lewis in his book, Mark Lewis in his book on the birth of the new justice. There is, I think, a chapter on the Geneva Convention, which is interesting. But the question is open. I'm not a specialist of this question, but I'm not sure the Geneva Convention has more leg than it's. I don't know.
Yeah.
Has it more leg than Nuremberg now? You think?
I think it does, but I mean, maybe it's a simple answer, like it just doesn't implicate race in the same way. That you can do more if I don't know.
And there was another question.
Well, no, let's just move on. Let's let others ask questions.
Yeah. So who would have questions? I think Andrew has one, if I'm right. Yeah. So Andrew, that's a question. Yeah, of course. Yeah.
Yeah. Okay. So I'll just introduce myself very quickly. So, and I'm Andrew Levitas. I'm a research fellow at Cambridge University. So I'm not a legal historian per se. So I'll sort of turn the lens a little bit. So what interested me, Guillaume, about the book especially, was the role of place, what you call a kind of space of experience in international lawyers and these European immigrants' experience of race, their understanding of race. And I think by this I mean exactly the American South, in a specific historical period, like a specific historical moment, the 1930s and 1940s. And I'm thinking of this, of like when Raphael Lemkin, he first saw the segregated restrooms in Lynchburg, Virginia, or his silences, his strange silence on the all-white segregated Duke University, and then on the other hand, someone like John Hertz, who began, one of the American prosecutors in Nuremberg, who began his career at Howard University, a historically Black university in the United States, and in Washington, D.C. And Washington, D.C. is an interesting place at that period, right? Because it's a largely African-American city, but at the same time, it's a Southern city. you know, are sort of dominated by kind of by Dixiecrats and that, you know, it's in a place of strict segregation. So I'm wondering how these places, how important was these experiences of place in these lawyers' understanding of race?
Yeah, Guillaume, yeah.
It's a very interesting question. Yes, Washington is the. There were a lot of contradiction in the United States, but Washington was the concentration of all contradictions. The city itself, because as you said, because Washington DC is one of the the biggest black African American cities, and it was dominated, as you said, by the Southern Democrats. In the Roosevelt era, it was particularly dominated by this group. I think, and it was also the place of the federal. It was and it is also the place of the federal government. It is the place where the government lawyers concentrated and still concentrates. And these government lawyers, to some extent, as I show in the book, are different from the Wall Street lawyers from New York. There is an interesting and complicated geography which is linked to this sociography of the actors of the time. You're right, but I'm not sure to answer the question.
Maybe Liz, could you provide an answer, or you?
Well, I think the invitation was just for Guillaume to reflect on it. So,
okay.
Yeah, I mean, it's a fascinating, I'm not sure duality, but just the figure of Raphael Lemkin in particular, where, you know, he really does not want to endanger his project, and this is a little bit later, of the Genocide Convention getting through the Senate. And so he just disassociates it from anything to do with racialized visions of justice, because he knows that that's, you know, a pit from which he will never escape. Yeah. And that he either chooses not to see it, or he proactively shuts it out, but he doesn't see how his arguments apply in the American South.
Oh, is it a recording?
No, it's very interesting, but I'm mute.
I hope you are.
Yeah, Parvati, yeah.
Hi, thank you so much. My name is Parvati, and I'm a researcher in the University of Helsinki, and I work on the concept of protection, empire, and international law.
Oh, great.
And I teach international criminal law, so therefore a bit of curiosity. So I was wondering, I mean, about the social study that you do about the American lawyers. And I'm curious what you discovered about some of the non-American lawyers who had a very important impact, like the Soviet lawyer Aaron Trenin, who tried very hard to expand the definition of genocide and wanted to kind of include a revolutionary movement, class struggle kind of approach. And why did that fail? And what was the pushback?
No, yeah. In my book, I mention the Russian jurist, but I didn't specifically work on them for very pragmatic reason. I don't speak Russian. I cannot have access to the archives, and I concentrated in this book on the American lawyers, the French also. It was at the beginning of it is a very long, I didn't say, but it was very long research. more than 10 years. and so is it. And in the beginning, I worked on the French and on the French lawyers, but my knowledge of the Russian is limited. Aaron Training is a very interesting figure. He's also one of the who conceptualized the notion of aggression during the war. He has important, significant influence also on American, British, and French jurists and experts. But I want to say something on Raphael Lemkin. I think Lemkin had like other immigrants from East Europe, the dictature, the Nazism, had a reservation towards the African American question. Had some reservation he shared with other immigrants. You mentioned it, Elizabeth, like Hannah Arendt and other. For them, the racism against Black Americans was something different than the racism or the anti-Semitism. It's difficult to articulate because it's a delicate question, but for them it was something a little different. Hannah Arendt was uncomfortable with this question. Lemkin also. Lemkin is not very. I don't know, how do you say, Anne-Sophie, mais il est un peu de mauvaise foi sur cette question. Tu
A little
comprends?
bit of bad faith? I don't know.
Bad faith, yeah.
He doesn't want to be tainted, you know.
Yes.
It's distasteful. I mean, he's got enough problems. He's Raphael Lemkin, but
bad faith because he didn't apply the same criteria.
Yes.
Regarding the racism of the Nazis and the racism in the United States.
Exactly.
Yeah.
Looks like Diane. Diane has a hand?
Tatiana, you had also a question, right?
Sorry. Can you hear me?
Yeah, we can hear you.
Yeah. No, I'm just repeating what Parvasi, right? Just asked about the Soviet, the lawyers from the Soviet Union, and just was interested in the Soviet view on this issue, sovereignty and persecution of domestic population and domestic minorities. But, it was already partially answered, so I just will pass.
There's a new book, if I may. There's a new book coming out from Francine Hirsch, who you cite her article, very important article about the Soviets at Nuremberg in the American Historical Review. Francine Hirsch.
Thank you.
And she's a Russianist, and she has a whole book now on the Soviets and their legal ideas and how they were overlooked, and kind of overdoes it a little bit in terms of seeing them as more influential than they were, just to counterbalance how they were unjustly overlooked. And a lot of that is for reasons that Guillaume has articulated, which is they didn't have the resources to play a very big role. A lot of the Soviet correspondence back to their supervisors is things like, our secretaries are not as beautiful as the Western secretaries. They don't have nice clothes, and it's making us look bad on the international stage.
It's very interesting. I actually have a question. Sorry. By the way, I'm Tatiana. I'm assistant professor of Japanese history at New York University, and so I'm doing modern Japanese history. And like my book just came out like last month, and it's called thank you. It's from Cornell University Press, and it's called Revolution Goes East. Imperial. Thank you. So it's Revolution Goes East, Imperial Japan and Soviet Communism. So I look at the reaction of the Imperial Japan and sort of various groups, state and non-state actors, and their reaction to the revolution and to the rise of Soviet state and communism as an ideology. So my question is, so I'm doing mainly pre-war period, and but in Japan and East Asia. So my question is really probably uninformed. So these American lawyers that you discuss in your book, are they overlapping with the lawyers who are in the Tokyo trial? Is there an overlap? Are they the same people? Are they in the same, running the same circles? Can we apply sort of your framework and how you kind of look at the background of these lawyers? Can we apply the same to the lawyers, American lawyers who are active in the Tokyo trial?
I think it's a question for Anne-Sophie.
Yeah, exactly. So when you, so I will answer very briefly, but when you look at the Tokyo trial, the question of the crimes against humanity is not at the center. So the Americans are going to Tokyo just to focus on the crimes against peace. When you look really at the archives, why? Because they want to accuse Japan for the attack on Pearl Harbor.
I may add that there are some overlapping between the staff, the Nuremberg staff and the Tokyo staff. In the French case, we find some overlappings. In American case also, but mainly the personals, the staffs were mainly different. Huh?
Thank you so much. That was really mind-blowing, and I really enjoyed the evening. I mean, this is so great to be able to be connected to people all over the world in just one night. So it was maybe more a reflection on the notion of minority and the minority question, and maybe the fact that some of the perspectives were different between state actors that were looking at minorities from a state, framework, and activists that took the trial as a way to legitimate their own struggle, but on a more grassroots perspective in movement, and trying to use the international level to then go back to the national level, but the perspectives were kind of different. And coming back for the Jewish advisors and lawyers that were part of it, I think that if you look at the long term and distance and period of time, then maybe the fact that the issue of the minority rights has completely changed in the life of these organizations that were founded at the very beginning of the 20th century. And so they are also leaning back on their own tradition as advocacy group. So yeah, that was like just a broad open question with no answer.
Guillaume, do you want to reflect on it?
But yes, in the book, it's another line of argumentation in my book, in some parts of the book, is also I try to reflect on the disappearance of the minority, the international law of minorities at the end and after the Second World War. the Allied expert decided, all agreed to abandon the interwar minority law, which was supposed in the interwar period to protect minorities. And the consensus after the war was to create homogenic states without minorities.
Hi, thank you. My name is Diane Marie Amen, and I am a professor at the University of Georgia, working on a book examining the women who played various roles at Nuremberg. And I want to, first of all, thank you, Guillaume, because you and I had an email correspondence about that, and I'm frightened that it was already a couple of years ago. These projects do have a life of their own. And I just wanted to, well, one thing I wanted to sort of adjust that was said about Tokyo and Nuremberg, I think there may be more to explore, at least from the American perspective. I don't know about others, but although the trial lawyers largely differed, and also the interpreters and analysts, there were a few who traveled to Tokyo after Nuremberg, but very few. At least in Washington, some of the same individuals were working organizationally. And so one of them is a woman named Eleanor Bontecu, who I think had been a dean at Bryn Mawr before the war. And she, as far as I can tell, may have never traveled either to Nuremberg or Tokyo, but was, she did a lot of the briefs in the case. I think she was the major writer in the Yamashita case before the Supreme Court. And so she was at a point in the legal department of the War Department, or maybe she might have been in DOJ, but in any event, she was very much a strategist. And at that level, there were people thinking about connections, disconnects, et cetera, between the American strategy in one place and the other. So, you know, one of the things that your book reveals is if you look at different pockets of participants, in your case, lawyers, you find out some interesting stuff, right? And so apropos of what Liz had said, your work is very convincing in answer to the question, is there more to be said about Nuremberg? And I think from my perspective, one of the reasons that I have pursued this for quite a while now is that the prevailing, not only popular political discourse idea of Nuremberg, but even the prevailing legal discourse about Nuremberg is largely positive, almost hagiographic, Amerocentric, or perhaps English language centric. And if you have that paradigm from an historical perspective, it's just waiting to be reanalyzed. It couldn't have been as good and as wonderful and heroic as most of the accounts say. And so I think really shining a light on the elite's treatment of race is really important. One of the things I found out from my empirical research, which is to a large extent based on personal papers, diaries, and oral histories of subaltern participants, is that race was constant in multiple ways at those levels as well. Because of where people came from, the Alabama secretary who washed out her white gloves every night so she could wear them to work the next morning. My observation is that there was quite a strong awareness of who was and was not Jewish among the participants, and that even the people who had fought the war in part to liberate the concentration camps, had not lost their prejudices, and vice versa. And so I think that your work begins to shine a light on a place where, in fact, there's some resistance for scholarship to go. There's a convenience in making Nuremberg an heroic moment. And, you know, so kudos to you for doing it. And I have your book right here.
Thank you.
I have read a little bit of it, but I've been, in fact, trying not to read too much because I'm trying to get my first draft out without being too influenced by others at this point. But what I've looked at is really great, and I appreciate this presentation. Thank you.
Yeah, thank
Thank
you.
you very much.
Guillaume, I will have a direct question because I'm finishing, so I'm rewriting my book, and so it's directly linked to the racist question. So because I'm focusing on the French trials in Saigon, and then you have and there is many parallels which has to be made, and then so in the constitution and the French new constitution in 1946, you claims the equality between people in the colonies, in the form, so in the colonies and the French. So it's inscribed in the constitution. But when you look at the treatment, at the real treatment of the person in the military trials, it is clear that you have a huge impact of racism. Just one example, you have the Vietnamese are not considered as equal as the French, and one of the war crimes against Japanese is that the Japanese put in jail French with Vietnamese. So if you look at in a global context, how do you see the persistence of racism in the post-war trials?
You mean only in the in the Asian case, or in general?
In general, because you have, for example, you have the new principles of Nuremberg, which is also in France. You have a huge publicity for this Nuremberg trial, and then in the colonies, for example, in the French colonies, you have racism, which is clear. So how can you explain it? So what would you So I have already my interpretation. So, but what would be yours?
Yes, also I have to mention here that my first research work was on justice during the Algerian War, and it was 1994, some few years ago, and I am still interested in the historiography of the Algerian War in France, which was marked by a very biased justice. Also, the practice of torture was massive. It was massive and systematic by the French army, and the justice never had any serious inquiry on torture cases, and the few trials were very often marked by racist biases, and the legacy of Nuremberg played no role. So the French. It's also interesting to examine what is the legacy, the legal legacy of Nuremberg in each national Allied state. in America, the implementation of or the reception of the principles of Nuremberg was very slow and very complicated. In France, there was no reception until the 60s. And when France sought to prosecute German war criminals like Barbie, who were abroad. But they never intended to use Nuremberg as tools to prosecute racist crimes or other hate crimes. So I think there is a very important disconnection between the international legacy of Nuremberg and the national practice, which is very far from this legacy.
Very much looking forward seeing you again. And so it has been a really nice and really interesting conversation and book presentation and interactions. And I thank you all for being here tonight.
Yeah, I want to thank you very much for your lecture, for your comments, and it was it is a pleasure to me, and I am very happy to exchange with colleagues in the USA.